Today, Advocate Andrea Johnson, the head of South Africa's elite anti-corruption unit, IDAC, is in the chair, and the case that put police generals in handcuffs is unraveling live, one admission at a time. It started as a complaint about crime intelligence, General Khumalo, General Lushaba, General Madondo, an affidavit alleging money siphoned from secret funds, drawn, it claims, from about 10 secret fund points across the country. But watch what she concedes, that IDAC went out and got the complaint itself. We're not supposed to solicit, she agrees, that the minister's letter, in her own words, doesn't trigger their mandate, that the founding affidavit gave no real grounds at all, and that she applied the wrong legal test, an honest error, she calls it. Then the chair delivers the line that says it all. This is a misuse of powers. Her answer? I have no comment, Chair. If you want to see how these cases are really built, hit like, subscribe, turn on the bell. Let's go inside.
But you seemed to be reading. You were looking down and you seemed to be reading.
I'm
surely,
I'm prepared to show this through counsel.
Okay.
Yes, that's
How did you vocalize the name then? Looking down as if you were reading it from a list. How did you come to vocalize the name?
I don't know why I said his name.
Okay, all
Sorry.
right. No, it's okay. It's okay.
The section of...
What do you mean when you say he had sight of it? Surely you understand the essence.
He saw the document.
Seeing as in, here's a document, it's lifted, and he does see it if it's lifted like this. But if it's immediately put back on the table, it's as good as not having been seen by him. So what do you mean by he did have sight of it?
So I'm giving you I'm giving you an explanation I get because I'm not inside of that room.
That's far you have not explained. That's why I want, what do you mean when you say he had sight of it? You have not explained it.
He saw the document.
I want to understand seeing. Is it in the sense of it being flashed? Here's a section 27 referral affidavit, boom. It's gone back to the top of the table and he doesn't see anything. Is that what you mean by seeing? Or do you mean it was given to him for him to peruse it for himself?
He was given the document to peruse for himself, according to him and to the team, much later on.
That's all I wanted.
Much later on.
Sorry, or much later.
With the exact answer.
Finally, do you dispute his version when he says before this commission that he did not see the Section 27 affidavit? Do you dispute his version? Do you say he's not telling the truth?
I'm unable to dispute his version because he's in that team. That is why I'm saying I have to ask the questions after the fact.
Thank you.
It's not my place to say he lied. He would have to, he explained as he did, yes.
Thank you. And thank you, Advocate Johnson.
Sorry, I didn't hear.
Did you act upon the letter? There is a specific request there to look into the complaint by Mr. Adams in respect of the cases listed there. And, as I say, at the end, to inform Mr. Adams of your decision. Mr. Ngabinde says, Honorable Fadiel Adams was advised by this office to await your decision in this regard. So I want to know, upon receipt of this letter, what steps did you then take? You have clarified that you cannot find a response to this letter, nor an acknowledgement of receipt.
And could not act on this letter because there were no attachments to it.
No, what you're being asked is that last paragraph says, Honorable Adams was advised by this office to await your decision in this regard. And the question is, having received a letter from the ministry, what did you do? Not did you institute an investigation? Was it a letter sufficient to act on it? That's not the question. The question is, you have correspondence directed to you. I assume you do not just file away letters when they come in, especially where you are told that the complainant is awaiting to hear from you. The question is, what did you do? Either you did nothing and filed this away, or you did do something about it, and you have to say, what did you do?
What I would have done, and that is why I'm saying I cannot find.
If you did do something, what did you do?
I honestly cannot remember. I have to cast my mind back to, in the acknowledgement of the receipt of the letter, I speak under correction. I'm not sure that I asked and indicated that there was nothing attached to this letter, because a few days later, by way of envelope, we get the Section 27.
You would have been told to file a Section 27. I mean, he didn't make it up. He didn't wake up one morning thinking, oops, I have to put in a Section 27 affidavit. So someone would have advised him to file that. That's why it's important to know, what did you do, what did you say in that acknowledgement of this letter. You must have said something before we get to, you then received an envelope.
And the acknowledgement would have been typed from an internal computer. Surely you have that letter in your possession, or a draft of it somewhere in the computer, and it can be made available to the commission.
We have looked for it. I'm going to ask them to look for it again, because I also have to apply my mind. I can't, that is why it sounds like a fumbling answer, because I can't recollect what I would have written over and beyond. We acknowledge a receipt, and in all likelihood would have alluded to the fact that there is nothing there, because it talks to this envelope coming with the 27 a week later.
But you see, speaking for myself, Advocate Johnson, the answer you've just given now creates an impression that a draft of this letter was deleted. That's why it's not available, because you use a laptop to draft a letter, and then your PA, I assume, would have then either printed it from that computer or emailed it to you. And if you are happy with it, you would have appended your signature, and it would have gone to the minister's office. Now, if you're saying we have looked and it's not there, the question is, what would have happened to that draft, unless somebody deleted it so that it is no longer available?
Now, I want to suggest to you, so effectively, IDAC solicited a Section 27 affidavit from Mr. Adams.
I tell you now, when you look, okay, when you look at the 27, we didn't take the 27. They would have contacted him, and I guess this is what we got. I speak under correction. Mr. Perumal would have to answer what he got from Mr. Adams, but what we got was a 27 dated the 21st of November, 2024.
That's fine. My question is, that document you're holding in your hand, IDAC solicited it from Mr. Adams. You received a letter from the minister. You then directed Mr. Perumal to act on that and contact Mr. Adams and
ask him for his...
Ask him. So you solicited a Section 27 affidavit from a would-be complainant.
I don't agree with the solicited.
Ma'am?
I don't agree with solicited. We would have asked him, because, you see, I'm going into the detail that's not mine and not in my head, and I don't want to sound like I...
It's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Then we would have obtained the statement.
At your instance, that's the substance of the question.
That is correct.
That's what Ms. Silo means when she says to you, so you solicited the affidavit, because what came out of your instruction that please contact Mr. Adams was the submission of the Section 27 affidavit. So it's on that basis that Ms. Silo is suggesting to you, you solicited that affidavit. Do you now agree?
I agree.
As you sit here today, is that appropriate of IDAC to be soliciting complaints from members of the public on the basis of which then IDAC initiates investigations?
No, we're not supposed to solicit. And that is why I'm saying I tell Mr. Perumal to engage Mr. Adams. I don't know if this was a prepared affidavit already. It was to say to him, we received a letter from the minister. We are engaging you. So whether this was already prepared or not, at the time, we got this affidavit.
Mandate in terms of Section 7A. Do these documents reflect a serious, a high profile or complex corruption, or a serious, high profile or complex, however that is read? What about the contents of those documents bring this within the mandate of IDAC to justify your initiative to direct Mr. Perumal to go obtain a Section 27 affidavit?
If this was in fact the document that was attached, it doesn't trigger.
And if that document wasn't attached, it's even worse, because the MK16 itself thus gets nowhere close to Section 7A on its own without this communication.
There's the two possibilities. If
Yes,
this was attached, the only time that it would have triggered anything however, I have been notified that the heart has followed the same as interfering in the investigative process. That might have triggered looking at whether or not there was defeating, but I can honestly tell you I can't recall this document, so it cannot have triggered IDAC's mandate.
We as IDAC cannot do anything. So that it would then have been the ministry that saw to it that a Section 27 referral was placed before IDAC. Why did you not write such a letter? Were you fearful of the minister?
Not at all, and that is
Why then did you not write such a
that is why
letter?
I said, Chair.
Sorry, you spoke over me. Why then did you not write such a letter?
That is why I said, Chair, we'd have to look for the letter that the response. What did I write in my response to the minister?
But
I
surely,
don't think that I
surely,
got a response.
sorry. But surely, that letter could not possibly have said, Minister, we are not going to do anything about this because there's no Section 27 referral, because that would have been at variance with or at odds with you instructing Mr. Perumal to follow up with Mr. Adams. So that letter, even if we were to look at it, it's not likely to have said what I'm suggesting you ought to have done. So do you think that letter is going to assist you?
I'd have to look at the contents.
Do you think it's going to assist you as you sit there, seriously? Do you think it's going to assist you?
Not at all.
It cannot possibly do so. It cannot possibly do so, because such contents would have been, as I say, at odds with the instruction you gave to Mr. Perumal. You agree?
I agree, Chair.
Thank you.
That conduct of yours to say to Mr. Perumal, to Chief Perumal, speak to Mr. Adams, makes sense only if you've seen these emails and you've seen that there are allegations of interception of dockets, as you were starting to say, that the email seems to speak to corruption of sorts. You have to have seen this. That's my proposition to you, that you must have seen these emails by the time or before you spoke to Perumal, and that's what informed you saying to Mr. Perumal, speak to Mr. Adams. What do you say to that?
I can't disagree with you, Commissioner Baloy.
Thank you.
Commissioners, I did call Mr. Perumal during the tea break, and I give feedback as follows. The referral and request for investigation in terms of Section 27 in the letter by the Minister referred to Honorable Fadil Adams and referred to dockets. The ID asked Mr. Perumal to contact Mr. Adams to find out if he had a 27, which he did. He called Mr. Adams to indicate that IDAC cannot assist you in the absence of a Section 27 referral. Mr. Adams said, I have dockets opened already that make out allegations. Mr. Perumal advised him that we cannot just take those dockets in the absence of a Section 27. He told him to see a legal person and look at Section 27, and if he was of a mind to then refer a matter in terms of Section 27. Accordingly, there is a 27 dated the 21st of November, signed in the Western Cape, that was compiled by Mr. Adams without IDAC, which he sent and which has the detail it has.
The complaint, the only complainant as at the 11th of November was the Office of the Minister. And that complaint concerned interception of dockets. So the complaint itself does not concern itself with the contents of the dockets. It's only the act of interception. Do you agree with me? That is what was communicated to you by the Minister's office on the 11th.
That these dockets were not with him. He was going to tell us where to find those dockets. In the interim, he then indicated that the dockets could be with the DPCI. When we contacted the DPCI, these dockets were not with them. And in that process, one of the investigators found out that the dockets actually were with the SAPS inspectorate, more so the head of the inspectorate, General Peter Jacobs.
And when was this discovery?
All on the 6th.
All on the 6th?
All on the 6th, because we're looking for the dockets. He's saying the dockets are missing. Do
you know how he discovered that, by any chance?
I know that the investigator indicated that he received information. I don't have the detail of the information, but he received information that the docket is with the head of the inspectorate, Lieutenant General Peter Jacobs.
Paragraph 1 reads as follows. In my capacity as a Member of Parliament for the Republic of South Africa, I first opened 3 cases in Cape Town Police Station with case numbers Cape Town, and they are stated. After I opened these cases, I take it I was informed that the cases were taken from the Cape Town Police Station to the Office of the Provincial Commissioner, Western Cape. I do not trust the Provincial Commissioner General particularly, and believe that a deliberate attempt is taking place to get rid of the cases I had reported and to protect those against whom I made the cases. End of quote. That is the investigation I'm asking about. Did you ever investigate the claims against General Particular? That is the interception. And I still don't understand whether or not you investigated that, you being IDAC, or you didn't. And if you investigated where you ever landed.
In all honesty, Council, I cannot tell you that there was a separate investigation about that interception.
Yes.
I know that we sought to find those dockets, and we then, in fact, found those dockets.
Your finding of the dockets surely doesn't address the complaint of interception?
No, it doesn't.
Yes.
In terms of what happened in the sequence would have been, as they identified, the housebreaking incident of General Lushaba. That was the first investigation. That was the first matter, counsel, that was enrolled. Thereafter, it was the Mokwele matter. There is then a third investigation. That is the one for which the warrants were held over, just for context, in terms of Lieutenant General Kumalo and General Madondo. And then there are other matters that also emanate from this complaint.
How many other matters?
There are, I know for 4, 5, there would be 6.
6 other matters.
6 other matters.
And they all, you say they all emanate from the Section 27.
That is correct.
Are you able, over the course of the lunch break, I guess, to prepare a list?
That?
At paragraph 5, he expresses a suspicion that some funds are being taken unlawfully from the secret funds account and given to Police Minister Becky Cele. At paragraph 6,
Before you do paragraphs,
my suspicion is that General Kumalo Lushaba Madondo and many of those who they've appointed are actively siphoning money from the secret fund accounts in the country. I understand that there are about 10 secret fund points in the country where monies can be drawn from, and all of these extraction points need to be investigated. That's another suspicion. At 7.
Factual conclusion after factual conclusion, Advocate Johnson can never give you the facts that undergird those factual conclusions. All of the things you are addressing now are themselves factual conclusions. Do you understand what I'm saying? Do you understand what I'm saying?
If you could just take me back
Those
to-
are factual conclusions. Let me
Yes.
give you, let me give you agree. Do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So if we go back to Ms. Silo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand. you.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of Section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Mr.
Thank you, Chair.
Was there a sufficient factual substratum to satisfy B of Section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of it, yes.
The factual basis that undergirds or supports the factual conclusion.
Correct,
You've accepted that there was none.
yes.
Do you then accept on that basis, because my and your engagement had started on the basis of the first suspicion,
Yes.
which is state capture, would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
His conclusions.
his conclusions of, I have information, and I receive information, and I also had information. It is
Now-
on that basis, yes.
If that's where we land,
The person test applies, but Adams,
Once, you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So
24, why did you treat this affidavit as an exception to the rule that you say you had come to apply to all other Section 27 affidavits?
so I'm not going back.
Yes.
And I think that is where my fourth line lay, is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error. The test isn't subjective, the test is objective. Here I brought a subjective mind to bear on the information.
Specified offenses as contemplated in 27 and 28.
Those are the offenses as set out in Section 7 of the Act that set out the offenses that IDAC falls within IDAC's
No, that's
mandate.
a different question. 27 and 28.1 do not say any offense, unless you read specified offense in 27 and 28.1 to mean any offense referred to
In Section 7.
in Section 7. Is that how you read it?
Yes. Because we have no other offenses. That specified offense is the one that was deleted. And they didn't.
So let's just be clear then. So your determination was that because these offenses are offenses referred to in Section 7, sub 1, capital A, that is good enough.
Correct, Chair.
Even if they are not specified offenses as contemplated in this statute.
Yes,
As
because
far as you are concerned, you still had a mandate to investigate them.
that is correct.
And that was your understanding.
It specifically identifies General Kumalo, General Kumadondo, and General Lushaba. We just did that exercise at the various paragraphs 2-4. I cannot find in the Section 27 the persons identified under items 4 to 12. And you recall that your testimony was all you had at the time was the Section 27 affidavit. Does not reference any of the people listed from 4 till 12. Where does your annexure get them from?
Johnson, I think the question is, who gave you these names? They're not in the affidavit. We can look at it for the next hour. You will not find the names in 4 up to 12. Somebody gave them to you. Who gave you these names? And under what circumstances?
This application came to me from the prosecutor.
So Ms. Ramsame will have to tell us where she got these names from.
That would be correct.
Okay.
Did you inquire from her where she got the names from when you know that you only gave her the Section 27 affidavit and you are quite familiar with it?
Yes,
Do you engage and say, who are these ones now? Where do they come in? How do they come in? They are not in the affidavit. You are not conducting an investigation yet, so you are not obtaining your own evidence. Where do these names come from? Did you have that engagement with her?
I didn't have that.
Why not?
You, the head, are not in a position, and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you. At this stage, this is a misuse of powers. To take intrusive steps and action against people on this affidavit, you have no justification whatsoever on this affidavit to be looking into Likalakala, Ngube, Moyani, Sibula, Madileng, Mokwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that. When in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. To me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
No, I have no comment, Chair.
Thank you.